Luxembourg court bailiffs issued fresh seizure orders for 2 units of Malaysian state oil firm Petronas this week. Following a bid by descendants of a former sultanate to enforce a $15 billion award they had won against Malaysia, according to the court document presented by the lawyer of the Sultanate Heirs. The Filipino heirs of the last Sultan of Solu are seeking to enforce a $14.9 billion award granted to them by a French arbitration court last year. Amid a long-running dispute with the Malaysian government over a colonial-era land deal, which is currently part of North Borneo in Eastern Malaysia. Malaysia, which did not participate in the arbitration, maintains its stand that the process is illegal, and has vowed to use all legal measures to prevent its assets, including state-linked companies, from being seized overseas. It obtained a stay on the award in France, but the ruling remains enforceable overseas, under a United Nations Treaty on Arbitration. Petronas confirmed the new seizure order for the 2 units under its parent company, but reiterated the heirs' actions were baseless, and that the company will continue to defend its legal position. Petronas will focus its efforts on validation proceedings in which the court will determine the merits of the claims. The Petronas Azerbaijan and Petronas South Caucasus units were first seized in July 2022, but the Malaysian government said last month that the order had been set aside by a Luxembourg district court. However, on Tuesday, Luxembourg court bailiffs issued a second seizure order on the units and related bank accounts, according to the court documents shared by the heirs' lawyer. The Luxembourg District Court had indeed lifted the first seizure order on a minor issue that has been addressed, but the modification had no effect on judgment and the merits of the arbitration. The dispute stems from a deal signed in 1878 between 2 European colonists and the Sultan of Solu for use of his territory in present-day Malaysia. An agreement that independent Malaysia honored until 2013, and paying the monarch's descendants a token sum annually. Kuala Lumpur stopped the payments after a bloody incursion by supporters of the former sultanate who wanted to reclaim eastern Sabah from Malaysia. The heirs say they were not involved in the incursion, and sought arbitration over the suspension of payments, while the Philippines government sought to distance itself from a controversy between next-door neighboring Malaysia and the heirs of a sultanate, who are trying to seize international assets of Kuala Lumpur's state-owned oil company, in lieu of a land dispute going back to the 18th century. The claim by the descendants of the Sultan of Solu is in the nature of a private claim, between 2 private parties and does not involve the government of either Malaysia or the Philippines. Therefore, it is not an issue of sovereignty, or of territory at the moment. This is a response in relation to recent reports from Malaysia that quoted members of the Sultanate as saying they hope that President Marcos would help them recover Sabah, which is part of Malaysian Borneo, and is close to the Sulu archipelago in the far southern Philippines. They pointed to a declaration made by Marcos during his first State of the Nation address last year, that, as president, he would not abandon even 1 square inch of Philippine territory. Though, technically, the heirs' claims did not constitute sovereignty at the moment. The heirs, reacting to Marcos' speech, had expressed hope that the new leader would work to reclaim Sabah, which has been the focus of a long-standing territorial dispute between the Philippines and Malaysia. While serving in the Senate, Marcos passed a resolution urging the country to actively revive its claim to Sabah. The Office of the Solicitor General of the Philippines is not discounting the possibility of interacting with the heirs of the Sultanate of Sulu or their lawyers, for possible collaboration in connection with their claim to Sabah. The Philippine government will consider that possibility if deemed necessary. Right now, no party involved in the arbitration has approached the government for any kind of intervention. The Office of the Solicitor General is studying the implications on the country of a French court ruling last March, awarding $14.9 billion United States dollars to the heirs of the Sulu Sultanate, which supposedly represents Malaysian unpaid payments due on the Sultanate's properties in Sabah under a centuries-old lease agreement. The heirs are trying to seize Malaysian government assets around the world in a bid to enforce a $14.9 billion arbitration award against Malaysia despite a stay issued by a French court. Malaysia, which had been refused to be represented in the Paris proceedings, is appealing the ruling. Even as reports say that supposed representatives of the Sultanate heirs have moved to take legal actions over Europe-registered assets, worth $2 billion of the Malaysian state energy firm Petronas. In February, a court in France had ordered Malaysia to pay the sum to the descendants of the last Sultan of Solu to settle a dispute over a colonial-era land deal. On July 12, however, the Paris Court of Appeal stayed the ruling after finding that enforcement of the award could infringe on Malaysia's sovereignty. On July 19, Malaysian Prime Minister Ismail Sabri Yaakob announced that his government would protect the country's assets abroad in the wake of the French ruling. He said a special task force was formed to investigate the seizure notice served on 2 European assets of the state-owned oil firm Petronas by heirs to the Sulu Sultanate. However, the proceedings taken by the Malaysian legal team show no effects on the seizure issued by the Luxembourg court, as a new order was issued to reinstate its previous judgment. The thorny issue of Sabah in terms of its diplomatic and political significance between the Philippines and Malaysia has been dealt with in a number of legal and historical articles, books, and monographs. Although some books partly discuss Sabah, they provide relevant and interesting information about its other unknown but crucial aspects. As a dependency of the Sulu Sultanate before and after the deed of 1878, Sabah was an integral part of the Sulu territory. Although the British North Borneo Company assumed the territorial rights over Sabah from 1878 to 1946, which period was interrupted only by the outbreak of World War II. Still, Sabah's historical development before and after 1878 should be situated in the context of Sulu's history. On this basis alone, Sabah should be incorporated as part of the areas to be studied in Philippine history, or on a smaller scale and scope, in the history of Sulu and Mindanao. However, before 1675, Sabah belonged to the Sultanate of Brunei, and as such, Sabah was crucial in the historical and political development of Brunei as a sultanate. The Philippine-Malaysia dispute over Sabah was, and still is, a contentious diplomatic issue. So, who is the real owner of Sabah? Apparently, Sabah is technically part of the federal state of Malaysia currently, when North Borneo was incorporated into the federation in 1963. But in the future, the thing seems uncertain. Currently, the arbitrary battle is between the heirs of the Sultan, a private Filipino citizen, and the Malaysian government. The Philippine government could step up and represent the heirs of the Sultanate of Solu as the successor of North Borneo. If ever, the 1878 treaty is still binding and enforceable, the non-payment of Malaysia of an annual rental since 2013 could result in a breach of contract, and as a consequence, the control and ownership of North Borneo can be taken back by the owner or to the heirs of the Sultanate of Sulu. This could be the reason why the arbitrary court in France awarded $14.9 billion, a bigger amount compared to the unpaid annual session money for 9 years. However, the Malaysian government won't budge an inch over Sabah and created a task force that has been set up to study all of Malaysia's overseas assets and protect the security and sovereignty of Sabah. But the real question is, was the incorporation of Sabah into the Malaysian Federation as legal and binding, based on the 1878 treaty between the Sultanate of Sulu and the British Empire? Or the 1878 concession treaty has a legal basis in the present day's international law system? Either way, both countries must respect any authorized arbitrary proceeding issued by the International Court, and be able to create a diplomatic concession for a peaceful resolution of the issue.